Lawyers are trained to give bad advice about trademarks. And here's why.
Get it trademarked with Trademark Factory.
Hi, I'm Andrei Mincov, the founder of Trademark Factory. I've been working in the field of intellectual property for over 25 years. I spent 8 years in a Russian law school and my PhD in law program. I worked as a lawyer in Russia for 11 or so years. I spent 3 more years in a Canadian law school. I was a licensed Canadian lawyer for 4 or so years before I relinquished my lawyer license to focus on building Trademark Factory in my capacity as a trademark agent. I've witnessed countless brand owners get burned by horribly dangerous advice about trademarks dispensed by American and Canadian lawyers. In this video, I'm going to cover some of the most problematic misconceptions around how trademarks work, but I want to make one thing clear first. Just let me get rid of this tie, because if my tie is the only reason you're listening to me, then we have an even bigger problem on our hands, right? All right, so to be perfectly honest with you, I don't even know how to tie my own ties. For 25 plus years of my legal career, I had to have them pre-tied for me. No, my wife does that for me now. Now, with that out of the way, let me make one thing clear. Lawyers are trained to give bad advice about trademarks. And here's why. It all starts in law school, where the first thing lawyers are taught to do is make arguments for both sides of the same case. Countless assignments are given to trained lawyers to provide on the one hand and on the other hand arguments. The foregoing notwithstanding, it can also be argued that subject to the judge's finding in such and such case, blah, 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 blah. It's in the lawyer's blood. To them, law is about coming up with a bunch of arguments for all sides and trying to come up with a persuasion strategy that would prevail in court. Now, here's the kicker. The vast majority of legal advice dispensed by lawyers never gets tested. 99.99 something percent. Why? Well, because the only way to truly test legal advice is to have the case heard in front of a judge and then survive all levels of appeal. That's when you truly know whether the advice you got was sound. But even then, lawyers will have used some weasel language to the effect that they can't guarantee a certain result and that things could go either way. It's just that they think that what they've suggested has a certain probability of happening. Now think about it. If a lawyer tells you that you have a 70% chance of winning the case, let's even assume that the lawyer's assessment is precisely accurate. All it means is that 3 out of 10 times, a case with the exact same set of facts and circumstances, you will lose. Heck, even if they give you a 90% chance and you lose, they always have a way to hide behind their prediction. Oh, too bad that you happen to fall under the 10%. But of course, there's no way to really know if you lost because you fell under the 10% or because your chances were lower to begin with. There are 2 things that matter the most to lawyers. One is not losing their law license. The other one is their fees. Most lawyers, when they give advice, worry more about covering their asses from possible complaints from their bar associations and law societies than about giving you practical, actionable advice. That's what they're taught in law schools, remember? That's also what they're taught during their first years working as associates in law firms. They spend countless hours writing memos full of, on the one hand, but you can also make an argument BS, right? They want to make sure that they've covered everything so that nobody could blame them that they didn't warn the client about how the law could turn out to be. Now, the best part is, since they bill you by the hour, law firms encourage these long-winded memos that go on and on and on forever, leaving the client with one question that never gets answered. What the fuck am I supposed to do? And what did I just pay $3,500 for? Lawyers don't want to take responsibility for giving clear and concise advice. Law schools and law firms train them to generate more billable hours while avoiding liability by providing meaningless advice that lists all obscure provisions and minuscule likelihoods of things going the opposite way. Now, what does this all have to do with trademarks? 2 words: common law. The most dangerous piece of advice, while technically correct by the books, is this idea that all you need to protect your brand is a common law trademark. Most people misunderstand it to mean any brand that you came up with before anyone else and that you didn't do anything to protect. That is complete and utter bullshit on 2 levels. First, in order for this to work, you need to prove that your brand is a common law trademark. And second, you need to prove that your brand is a common law trademark. Now, you coming up with a name does not make it a common law trademark. You starting an LLC or registering a domain name does not make it a common law trademark. You launching a website that barely has any visitors, or your local corner store selling a couple of $1,000s worth of your products, does not make it a common law trademark. What makes it a common law trademark is when a significant number of people across the country have come to recognize your brand as your brand. Failing that, you ain't got a common law trademark. And even if you think you have a common law trademark, it's not enough until you prove that you have a common law trademark in court or as part of opposition proceedings. Proving means you need to provide evidence and arguments that you're known to a significant number of people across the country. It means securing witness reports, surveys, lawyer arguments that present your case in a favorable light. This can easily cost $50,000 and up. Now, even worse, it will take years before you actually get a final decision that recognizes your common law trademark. And in case of you launching opposition proceedings, it means that you need to somehow monitor Trademark Office's database in the hope of catching applications for similar trademarks during the short opposition window. Now, can this be done? Yes. Is this technically correct from the legal perspective? Yes. But this is also a really stupid, unreliable, expensive way of protecting your brand compared to just getting your trademark registered through the Trademarks Office's system. That's why that system exists. Now, announcing that you want to save money on trademarking because you're relying on your common law trademark is just about as smart as saying that you're saving money on restaurants by buying a farm to grow and butcher your own cow to make a burger. It's pure insanity. But lawyers will happily sell you this idea because guess who's going to bill you to prove in court that you have a common law trademark? They'll share your righteous indignation and say, yes, you have a reasonably high chance of proving that you have a common law trademark, and you have a great chance of winning this case. It will only take 3 years and maybe about $100,000, and they will work super hard. Except compare that with simply filing a trademark application with a trademarks office, which is a much more straightforward, quick, and inexpensive way to protect your brand. Oh, and one more thing. When you go to court to prove that you have a common law trademark, after you've wasted 3 years and $100,000, what if you actually lose? What are you going to do then? And in case you're new to this channel, with Trademark Factory, we offer a 100% money back guarantee in case your trademark doesn't get approved by the Trademarks Office, which incidentally, no other firm in the world does. I want to leave you with just one question. Do you still want to go the common law trademark path?
Get